I'm often asked by opposing counsel, why is it unwise to just allow design and construction litigation to run its course? Why shouldn't we just charge forward in litigation and sometimes arbitration and take advantage of these adversarial procedures for exchanging information, depositions, discovery, motion practice? And before I answer the question, I should make the point that I am not against litigation or arbitration. Nothing could be further from the truth. I think that they're very important means of resolving design and construction disputes, and I represent plaintiffs and defendants in litigation now and always. I have for more than 20 years, and I expect that I will for the rest of my legal career. And I think that litigation is certainly fine in a variety of contexts that don't necessarily apply to design and construction disputes, right? I think that litigation can be incredibly important when the dispute's about more than money. For example, if you need to bust a patent rather than waiting 20 years for it to expire, that's a really good reason to charge forward with civil litigation. And certainly, if you're in a personal injury lawsuit and there's a wide disagreement between what the recoverable damages should be, one party says 50 million, one party says 50,000, then yes, go forward and take the case all the way to trial. And certainly in cases of criminal law, if people are facing criminal prosecution, you have to respect those who want to avail themselves of their constitutional right to trial. These are all great reasons to charge ahead with trial. And certainly in the design and construction context, there's a huge number of reasons why it makes a lot of sense to charge ahead with litigation or arbitration. And certainly in the context of litigation, you can't foreclose a mortgage or a mechanics lien, in a mediation. You could certainly try to resolve, those disputes short of needing there to be, court resolution. But only judges can, order property to be sold and can, render declaratory judgments on, what insurance coverage, is or is not provided under a policy. So there certainly are a wide variety of contexts where litigation and in some cases arbitration can be very useful. So I'm not making a blanket argument that we should prevent all design and construction litigation from running its course. But I would just say that the caveat is that there are many other areas of law where it makes a lot more sense for cases to go to trial, because in many of those cases, the disputes are about more than money. Design and construction disputes tend to be very different than most other commercial disputes. One example that comes to mind is there's generally not situations where there's a 10 times or 100 times disagreement about what the recoverable damages are. I mean, certainly claimants take extreme positions and they're often met with aggressive defenses that include a position that they're entitled to a lot less money. But if we're looking at the calculation of damages, if we're looking at quantum, when I am dealing with experienced design and construction attorneys on the other side of the dispute, generally speaking, if we're all acting in good faith, we're going to be able to apply the measures of damages to the dispute, and we're going to be able to agree early about what the likely recoverable damages are. And that's different than other areas of law. And this is one of the reasons why design and construction disputes lend themselves to early resolution. This is just one example of things that we really ought to be able to agree on earlier. And I think that I don't know that litigation discovery conducted on an adversarial basis is really essential to give clients enough information to make a business decision about whether to either settle or fight on, for reasons like I was just, describing. Design and construction dispute, it's a niche area of law. There's some very well understood principles, and, experienced design and construction lawyers perhaps are able to get more on the same page than lawyers who are doing battle in other areas of law where it might make more sense to go to trial. And I think that it's not true that discovery is necessarily required to help our clients decide whether to settle. And here's the reality, at least in my view, even the best prepared cases, I don't know that the gathering of the evidence in litigation discovery really helps to accurately predict what the outcome of the dispute is. And I wish that I could attribute this quote somewhere, because this certainly isn't, these aren't my words, but I read somewhere that somebody said, we start off knowing 80 to 90% of the facts, and we spend 80 to 90% of the costs trying to discover the other 10 to 20% of unknown facts. And, we wind up learning essentially nothing that's all that important. And it's true that more litigation discovery may help the parties better understand the strengths and weaknesses of the parties' relative arguments. But I would push back on the idea that clarifying the strengths and weaknesses is always constructive. I think it often only escalates impasse as each side wants to kind of prop up its strengths. They want to say, I'm going to look at it this way, and I'm going to look at it that way, in the hopes that doing so will overcome, the weaknesses in their case. Traditionally, in my experience of 20 years of going into court and litigating, this results in expensive and time-consuming discovery conducted on an adversarial basis, which again, does this tend to promote early cost-efficient dispute resolution? No, it does not. And if people wanted to argue that discovery, this expensive and time-consuming evidence gathering, this aggressive discovery that's often conducted by lawyers, who drive antagonistic behaviors between the parties, if we're going to argue that is really essential because we're going to trial, I'd ask the question, how come so few of these cases actually wind up ever making it to trial? I think that whatever parties are saying to themselves in the early going, where they decide that we're just going to let the litigation run its course, seems to me the blinding flash of the obvious is that unless it's the one case in 100, and I don't have numbers here, I'm just shooting from the hip, unless it's the one case in 100 where the parties actually decide to take the case to trial, then I think if we rewind the tape to the beginning of the dispute, and I am unable to overcome people arguing to me, let's just let the litigation run its course. Seems to me that if they eventually settle on the courthouse steps on terms that are quite similar to what could have been achieved years earlier without putting our clients through all that expense and inconvenience, that there's something broken in the process. There's something, broken in the mentality of people who, want to just allow the design and construction litigation to run its course. Because if we miss that opportunity to have early cost-efficient dispute resolution, the conflict escalates. The parties go to war in this window of opportunity for a early cost-efficient dispute resolution passes, which is really a shame, because I think it's almost always the case that those who own companies who design and construct would rather ply their talents and spend their time building and designing and bringing to the fore these wonderful spaces that we all enjoy. None of them want to get drafted into service by an attorney who wants a couple hundred hours of their time to prepare for a trial, which is very unlikely to actually occur. And rather the case will likely settle too late and after too much expense and inconvenience by our clients.